On August 16, 2021, Justin and Aaron Riddle were sued by Charter West Bank in the Douglas County District Court of Nebraska. The bank alleged violations of the Anti-Cyber Squatting Consumer Protection Act, ACPA, and trademark infringement stemming from the couple's registration of a domain name used to publish a website called Corruption Report after a dispute involving a mortgage transaction. In May 2021, the Riddles registered the domain while their disagreement with the bank was ongoing. According to the bank's court filings, the couple later offered to transfer the domain back for $1 million, a proposal the bank described as an attempt to leverage the domain for financial gain. Representing themselves throughout the case, Justin and Aaron Riddle challenged the bank's claims without legal counsel. The Douglas County District Court ultimately ruled in favor of Charter West Bank and issued a permanent injunction against the couple. On March 29, 2023, the Riddles appealed that decision to the Nebraska Supreme Court, seeking to overturn the lower court's ruling.
Very good. Then, Mr. Riddle, you may approach the podium and you may proceed.
Thank you, and thank you, Your Honors. May it please the court, Mr. Silver, members of the gallery. My name is Justin Riddle. This is my wife, Erin Riddle. We're here today as pro se litigants in this matter. Our lives, like anyone, were constantly evolving. After several years of hard work, saving, budgeting, and debt reduction, we were ready to purchase a home. We worked with Charter West, but at a point in the process, we were uncomfortable with their operation, decided to withdraw our loan and work with a different bank. In retaliation, Charter West put a code in the FHA system that indicated a non-existent child support obligation was past due. This prevented us from consummating our agreement with the new lender, as it's a system that every lender uses, but only the lender who put in the code could fix. After months of bootless requests asking Charter West Bank to correct the record, it was clear they were not going to remove the lies, so I proceeded to file a lawsuit. When it became obvious that we were not being treated fairly by the court, I decided my best course of action was to make a public gripe website. I researched the laws, and once I understood what was allowed, I alone, without the consent or knowledge of my wife, went to GoDaddy and searched for a suitable URL.
Mr. Riddle, just more for the benefit of the folks watching, the court to which you referred where you felt you were not being fairly treated, to what court were you referring to?
That would be the district court, the appeals court as well.
In the federal system.
Mm-hmm.
So not in the state court system?
Well,
The one you were talking about was the federal district court, and which then was appealed to the Eighth Circuit Court of Appeals.
correct.
Now, you may get around to something else, but I just want everyone to understand what you were talking about.
Thank you.
You're welcome.
Your initial lawsuit was filed in the federal district court.
Yes.
All right. And there was motions to dismiss. The court dismissed certain parties. And did you appeal that to the Eighth Circuit?
I did.
Okay. And then you filed is there another action now in state court that we're here on today?
Yes, that's where I'm getting to.
All right. Very good. Thank you.
Incredibly, charterwestbank.com was available. I immediately purchased it and did additional research to verify I could legally use that URL. According to the Lanham Act and a very clearly defined fair use doctrine, because I'm not a competing business and my site is entirely set up to criticize, I am legally allowed. Charter West has decided to sue us for that website based on the Anti-Cyber Squatting Act, which brings us here today. Cyber squatting was the choice for the plaintiff, as it's the one and only way that someone can obtain a website by force. There's no other remedy in law that forces the transfer of internet real estate. However, Charter West has fallen short on their claim on every avenue, and I'll explain how.
Just to, again, be clear for the benefit of our audience, the Cyber Squatting Act to which you have referred is part of the Lanham Act, but there are other parts of the Lanham Act.
Certainly.
And when you were talking about having researched the Lanham Act, you were perhaps talking more broadly than just the Anti-Cyber Squatting Act?
The fair use doctrine was more broadly, but as far as the Lanham Act, I was very specific with cyber squatting.
That's okay. That's what you're talking about.
Correct.
All right. Thank you.
Okay,
Thank you.
Let me just pursue that from a statutory standpoint. So this case is in the playground of the anti-squatting statute? Okay. And there are elements that would need to be proved by a party claim?
Precisely.
Claiming. Okay. And generally speaking, what are those elements?
Well, to qualify for protection, one must either hold a trademark or be so well recognized on a national or global scale that their name would be sufficient for most individuals to know who they were. Charter West does not hold a trademark to my domain name, although if they did, the fair use is affirmative, and I've proven it several times.
When you say they don't hold a trademark to your domain.
Yeah, they're not trademarked.
Well, I just hold it. So,
sorry.
To be precise, I mean, you don't trademark a domain name, you trademark a name.
Correct.
And your contention is they do not have a trademark for Charter West Bank.
Correct.
So the statute and the cases are referring to mark, not trademark in the.
Service mark, trademark.
Well, they're not fungible. So under the anti-squatting statute, the mark needs to be confusingly similar, right?
That would be one. That would be
That would
one.
be one of the elements, right? But it's not the same as trademark of likelihood of confusion. They're not the same. Do you agree?
I would agree, yes.
Thank you.
Thank you, Your Honor. Additionally, notwithstanding the rest of the world, most people in Nebraska don't know whether Charter West is an Oregon-based shipping company, California travel agency, or Nebraska bank, because they're not well-known and large, thus disqualifying them from the other prong.
There are two words used in the phrase to which I think you are referring, distinctive or famous. Are you talking about both of those words, or are you talking about just famous?
Famous.
What about distinctive?
It's not trademarked, so it doesn't have any, there's no protection for that.
When you say it's not trademarked, are you saying there's no evidence that they have a registered trademark?
Correct.
The USPTO?
Would I be able to step to the next prong? I think it'll answer all the questions. Thank you.
Sure.
In case the lack of qualifying conditions does not on its own satisfy the court, there is a second, standalone, fundamentally more important area the claim fails. Public criticism, parody, gripe websites are constitutionally protected activities. When I purchased the site, I immediately started cataloging the way that Charter West had fabricated information to damage us, the little guy. It's easy to explain through a website. I'm going to skip some of this. But in order to win this case, Charter West must prove I was acting in bad faith. This is simply impossible to do based on the factual and legitimate gripe that initiated my complaint prior to purchasing the website.
It seemed that the district court, the state district court, was concerned about the offer to sell the website for $1 million. Does that have any impact?
I'll skip ahead to that. You will see an email string from the plaintiff titled "Settlement Offer Withdrawal" was allowed into evidence despite my objection because, as Judge Durr insisted, quote, "It's not an offer of settlement because there could be some more nefarious information contained," simply meaning that he would allow those emails with an open admission that he could use them as a fishing expedition. So let's just skip to because we're running low.
Before you move on, with regard to your bad faith argument, are you saying there could not be bad faith here because what you were asserting was true?
Correct. It's not only true, it's legal. And I haven't impersonated the bank. I haven't tried to sell bank products. Anything is for sale. If the bank wants to buy the website, I can sell it to them. That's not cyber squatting. I mean, it's defined, and I just haven't done that.
It's defined, and bad faith has 9 statutory factors of bad
Correct.
faith, right? 15 U.S.C. 1125, D1, B little 1. Did I do it? Okay, so, right?
And there are
they're
other
not
things that
exclusive.
can be considered as
Right,
well.
Right, and that is kind of a reference for analytical
Exactly.
purposes. Right, okay.
And then I would also like to mention, if there's any remaining doubt, all one needs to do is visit www.nissan.com. You'll see that it's currently owned as a gripe website, and that www.nissanusa.com is what the world's 9th largest car manufacturer and 157th largest company owns. I pray the court upholds the same decisions as every other high court regarding gripe websites and move them for to dismiss with prejudice, as there's really no other legal question to answer. I would like to reserve my remaining time.
You may.
Thank you.
Thank you very much.
The court record shows that Mr. Riddle registered the domain after a dispute over a denied FHA mortgage loan, which he claimed resulted from the bank's mistaken handling of a child support obligation. Although the Anti-Cyber Squatting Consumer Protection Act, 15 U.S.C. Section 1125(d), prohibits registering confusingly similar domain names with a bad faith intent to profit, Mr. Riddle argued that his actions fell within the law's safe harbor provision. The Riddles maintained that their website was a non-commercial gripe site protected by the First Amendment. They argued that using the bank's name was a form of nominative fair use, necessary to identify the subject of their criticism rather than to mislead the public. One of the central issues in the case involved the couple's request for $1 million. While the bank described it as an attempt to ransom the domain name, the Riddles insisted it represented a proposed settlement of their broader mortgage dispute, not a demand for the website itself. When the case reached the Nebraska Supreme Court, the focus shifted away from the couple's conduct and toward the bank's trademark rights. Because Charter West Bank did not have a federally registered trademark at the time the lawsuit was filed, it first had to prove that its name had acquired distinctiveness, also known as secondary meaning. In other words, the bank needed to show that the public specifically associated the name Charter West with its institution rather than viewing it as a general geographic description. Representing Charter West Bank, attorney Jeffrey A. Silver argued that the Riddles' $1 million proposal should be admitted as evidence. He contended that the offer was not part of protected settlement discussions, but instead demonstrated an independent attempt to profit from the domain name. Relying on Nebraska's rules of evidence, he argued that the demand fell within an exception allowing such evidence when offered for a purpose other than proving liability.
Mr. Silver, good morning to you.
Good morning, Mr. Chief Justice. Your Honors, my name is Jeffrey Silver. I have the privilege of representing Charter West Bank in this matter. This is not a freedom of speech case. This is an internet blackmail case. What this gentleman did was buy a website that he found that, unfortunately for Charter West, they did not have, and he bought this domain site, and he did it for one purpose only, and that was to injure and damage Charter West. The emails that are a part of the record, I think, reflect astonishingly what his bad faith is, if I may.
May I jump ahead? And
Sure.
that is, I think you mentioned this injury to Charter West. What is the injury to Charter West on this record?
The injury to Charter West on the record is the confusion that it's going to cause with respect to its website that it has, that we have in the record.
Is that prospective, or is that already happened?
I'm sorry?
Is that prospective, or has that already happened?
That is, well, in one of his emails, and I'll reference it for you, Mr. Chief Justice, he says the damage is going to happen and we're not even going to know about it. So the fact of the matter is, there may be damage happening to us.
But then you're all speculating.
Well, you can't speculate about the damage because he's telling us in his email that the damage is going to occur and we're not even going to know that it's occurring.
Well, is this your proposition that some navigational miscue results in damage automatically?
No, it's not a navigational miscue. It's an intentional, purposeful attempt by Mr. Riddle to damage the bank by having his website or this website put up and make believe it's Charter West Bank.
But I think you answered it with the answer to, was there evidence of bad faith? And evidently you believe so, and we
Yes,
accept that's your position.
if I may.
But
What about all these cases that seem to say gripe websites are permitted? Do you disagree with those cases, or is this case distinguishable from those?
This is not a gripe site. I understand that gripe sites are okay. If somebody wants to make a gripe site about Charter West being really bad and not doing everything, that's fine. That's certainly protectable. This is not a case about a gripe site.
What distinguished this from those
Because
cases?
in his if I may. In his, or our exhibit number 3, he says in his email, "By next Wednesday, I can absolutely annihilate your client. Please play your game." He does not indicate that he has a problem with Charter West or a problem with Charter West in terms of how it handled his loan, which was already decided by the district court, federal district court, and then held up on appeal by the 8th Circuit. He's wanting to damage Charter West. It's different in my mind from saying a gripe site.
Hold on one second. Isn't that the case for everyone that wants to operate a gripe site? I mean, they're displeased with their experience with the company, and they want other people to know about it. What's problematic about that?
It's not problematic to have a gripe site, but if you look at the context of all the emails, first of all, he buys the domain name, then he wants to sell it, which is exactly what the Anti-Cybersecurity Act talks about.
It's the request for payment.
Yes, is different than just a gripe site. And interestingly enough,
Suppose he had registered IHateCharterWestBank.com. Would the Anti-Cyber-Squatting Act apply to that?
if you just had that domain name, the answer would be no. But that's not the case in this case. Not only does he have the domain name, but as part of the Cyber Squatting Act, he has to sell it or you have to want to do it for commercial purposes. The emails say he wants to sell it to us, he wants $1 million from us to buy that domain name. That is different than what Judge was talking about as a gripe site.
One of the assignments of error that your opponent did not particularly talk about this morning at any length was the argument regarding Rule 408 and his objection to the evidence on that ground.
Sure.
What's your take on that?
My take is 27408, and this court said in the McGill restoration case that settlement discussions are immunized from being admitted into evidence. This was not a settlement discussion. This was a threat made by him in various emails that we have in the record to destroy Charter West. This is not a case where he said, I want X in exchange for X, I'll give you Y and we'll settle the case. These are threats. And if you look at 27408, it's a lot different, and 27408 talks about offered for another purpose. This was not offered for the purpose of demonstrating liability to us for the loan process, which has already been litigated. This was offered to demonstrate the threats that he was making against Charter West as a result of him being unhappy. And the fact of the matter is, going back to your point, Judge Papik, there are emails where he has other websites that he wanted to buy. He got WW Nebraska Corrupt Banks, WW Corrupt Nebraska Bank. He could have all those domain names, and under any one of those domain names, or if he wants to have his own domain name, he can have that, and he could say all the bad things he wants to say about Charter West, subject, of course, to perhaps.
You pointed out emails, several times to support your argument here. Was there anything actually on the website that you're asserting is disallowable?
We did not see anything on the website that was offered. All we offered into evidence to support our position were the emails where he demonstrated, one, I want to sell the domain name back to you.
So to answer my question, there's nothing in the record that shows that there was anything on the website that was disallowable?
That's correct, Your Honor. We agree with that.
So the crux of the case is the offer to sell for $1 million.
I'm sorry?
That's the crux of the case, the $1 million offer or sale?
No, that's not. That's part of the case. Part of the case is also I want to annihilate you, and it's also part of the case where he wants to sell the domain name back to us. If you go back to the Anti-Cybersecurity Act, it talks about trying to sell it. So he bought this domain name, or I don't know how much he paid for it, we don't know that, but he has the domain name, and then he wants to sell it either to us, or if we don't buy it, he's going to sell it to somebody else.
If he'd offered a different number, less than $1 million, would that be a violation?
Yes, because
if he offered to sell it for what he bought it for, would that be a violation?
Yes, because if you're talking about, if you look at the act, it talks about selling it for a commercial purpose. And here, it doesn't matter if he was going to offer it to us for $1. He was selling it for a commercial purpose, which brings him squarely within the act. And that's why Judge Durr was correct in issuing the permanent injunction.
There still have to be bad faith, though,
So
wouldn't
you
there?
think that goes to the bad faith intent to profit from the use of the name as opposed to owning the name?
I think that goes as one component of it. I think the other component of it is if you look at the threads through the various emails, when he says, I'm going to annihilate you, I'm going to damage you, talking about Charter West, in connection with the sale, it all puts together a purpose. This is not, as Judge Papik asked before, this is not a gripe site. You want to have a gripe site? Be our guest.
Before your time expires, I want to expand on your last thought there. In response to one of my earlier questions, I thought you agreed that a website like I Hate Charter West Bank would be perfectly legal.
If standing in and of itself,
Okay.
I don't know that we could stop that. But
Now, I want to talk about the scope of the injunction that was actually granted. And I think you can see where I'm heading with this. The scope of the injunction was not just using this website, but any other domain name containing the words Charter West.
yes.
Is that defensible?
I think it is defensible.
Why?
Because when Judge Durr, if you recall the sequence of how we got back to Judge Durr, we went back to him on a rehearing. And initially, he did not issue the injunction because he thought we had not demonstrated damages. But when he looked again at those emails, and he looked again at what the purpose of those emails were, and the fact that I think the most important part of the response to you, Your Honor, is he tells us, Mr. Riddle tells us in his emails, you will not know the damage that we are causing. So I think Judge Durr understood that because we're never going to be able to know the damage that's going on, he decided that it was the best thing to do was just to
Well,
stop.
take an easy case damage, like somebody is redirected, right, to the website that's, quote, squatting, right, and buys stuff there instead of where they really intended, right, to go to the authentic vendor. Now you know that's redirected business.
Yes,
Okay.
yes.
What's the injury again?
The injury is certainly,
Based on evidence.
the injury is that people that are going to want to do business with Charter West, and I think in the record demonstrates that Charter West has remote banking. So we have remote banking. Somebody is going to go to that remote banking and see his domain name before they're going to see Charter West's domain name and think,
But he's not selling mortgages.
certainly I agree with that. But I don't think that frankly, Your Honor, I don't think that makes a difference that he's not selling mortgages.
Didn't the website actually say, we're not Charter West Bank, right in it?
He had that on as a disclaimer, but that's after the fact, Your Honor. You get to the website. If you're a customer of Charter West and you go to their website and you see his domain name, then you have to go through, well, we're not Charter West. How do you know we're not Charter West? I don't think that disclaimer takes.
Does Charter West have on its website, we're not Charter West?
We do.
You say that you're not yourself on the
we don't.
website?
Well, no.
Okay.
Is there evidence in the record that there's a mark that is famous or distinctive?
I would say, Your Honor, we acknowledge we do not have a trademark.
So what gives you protection under the Act?
What gives us protection under the Act is the fact that we have a domain name, multiple domain names that have the name Charter West in them.
You concede that there's no evidence in the record of a famous or distinctive mark.
I would agree with that. We do not have that registered as a mark.
And I'm not asking about registered. I'm not asking about registered with the USPTO. I'm
And
saying
the rest of the answer was, we don't have anything that indicates that it's famous
distinctive. Is
or
there evidence
distinct.
that it's distinctive?
Or distinct.
Aren't
we do.
those requirements to proceed under the Cyber Squatting Act?
I don't think they are. I think if you look at the Act, it does not require you to have a trademark, or it does not require you to have a specific, distinctive, famous, or whatever adjective you want to add to the world.
Okay, let's say I open a store and I call my store Hamburgers because I sell hamburgers. And someone else then gets the domain name hamburgers.com. Can I bring a cyber squatting claim and say, I got a mark, my store is called Hamburgers?
No, because
What's different about this?
The difference is, not only did he get the name, but he wanted to sell it also. That's what the critical difference is. It's not just having the name. You can have hamburgers, and I can go out and get and open up another store right next to you that says hamburgers. But if I buy the domain name hamburgers, and then I come to you and say, you know what, I have the domain name hamburgers, but I'm going to sell it to you for X dollars so that you can take me out of the picture, then I think you're bringing yourself within the purview of the act, and then I think we have something to talk about.
Chief, can I ask one more question?
You may.
You had said this is not a gripe site. Why is it not a gripe site?
It's not a gripe site because a gripe site doesn't involve somebody wanting to sell it. What happens is...
The key difference is wanting to sell it.
Yes, and not only wanting to sell it, but offering to sell it, not only to us, but indicating that if we did not buy it, he would sell it to somebody else or some other trust that would take him out of the picture. So I think that makes a critical difference between somebody having a gripe site. Like I said before, if he wanted to have Bank Nebraska's, pardon my French, suck and talk about Charter West, perfectly okay.
Thank you.
Thank you.
Mr. Riddle argues that the allegations of cyber squatting and blackmail are based on a misunderstanding of the Anti-Cyber Squatting Consumer Protection Act. He maintains that the law requires proof of a bad faith intent to profit, an element he believes is entirely absent in the operation of a non-commercial criticism website created to exercise First Amendment rights. According to Mr. Riddle, the communications the bank labeled as blackmail were actually protected settlement discussions under Nebraska Evidence Rule 27-408. He contends that offering to remove or stop publishing criticism in exchange for resolving the underlying mortgage dispute was a legitimate settlement proposal, not an act of extortion. In his view, those communications were part of an effort to resolve a legal conflict rather than exploit the domain name for financial gain. A major focus of the appeal, however, involved allegations of evidence spoliation and violations of procedural due process. Mr. Riddle claimed that an altered or incomplete document submitted during the litigation amounted to fraud upon the court. Invoking the doctrine of spoliation, he argued that the bank's failure to preserve the original evidence should result in an adverse inference, meaning the court should presume the missing or altered evidence would have been unfavorable to the bank's case. Mr. Riddle further asserted that the lawsuit had become a tool to silence criticism rather than resolve a legitimate legal dispute. He argued that the vast financial resources available to a large banking institution created an uneven playing field, making it extremely difficult for an ordinary citizen representing himself to receive equal treatment in court. Citing principles of equal protection, he emphasized that courts have long recognized that self-represented litigants should not be held to the same technical pleading standards as experienced attorneys. He concluded that unless the appellate court addressed the integrity of